Peace to the family. Everything is good. Hello. I'm not good at exactly talking. I'm much more of a impactful person. I don't really like to talk a lot. I listen more than I talk. I don't know how to say this, but I'm speaking directly to all of you, every elected official, Democrat, Republican, Autobot, Decepticon. I really don't care if you had 1,600 or not. Every government agency out there. I'm going to say this, and I'm going to say it plain and clean and clear. Release my children, or you will see things that you've never seen before in your life. You understand me? Now, if you're stupid enough to lay hands on me, the rest of the world will ask questions why. That's one of my children that you couldn't steal right there. That's it. You can try and charge me with a threat. You can get new bodyguards. It doesn't matter. Your jails can't hold me. The police can't arrest me. You can't beat me mentally, physically, spiritually, emotionally. In no way can you beat me. I will whoop your ass in court. I will whoop your ass physically. Write it down. Take this message and put it into record and try and charge me with something. Better look at my arm again. It's not a game. So I've said all I can say. I told the family that I was going to go live, but I'm not good at live. So I had to do it like this so I could do a little bit of editing to it and make it nice and clean and everything like this. But this is how it had to go. So thank you to the family for listening. That's all I needed. Appreciate it. Like I said, I'm going to do a little bit of editing to it. So again, the message is clear. You have a small window of time. I'm looking at the corner of my MacBook right now. It's 17 October. You got 13 goddamn days to release my children. Or what you saw happen with George Floyd will pale in comparison to how loud shit will get if my children ain't released. You can say what you want, do what you want, think what you want. You can make up fake charges. I tell you what, you better have every police department that you have available around where my children are. You understand me? And you still won't be able to stop me. Okay? So the date for that, matter of fact, let me give it a solid date. I like numerology. We're going to go with 11/11. So you have all the way up until the 11th. I already told the fake ass White House, that fake ass president, half of these fake ass elected officials, all of your asses are put on notice. You ain't shit. You ain't never been shit. And now I'm telling the people, right? I'm stating facts. I'm putting it on the record. Hold on. Matter of fact, just wait right there. I got to make this complete. And just like that, I'm back. So what I have in front of me is just a couple of the things that I can go ahead and read off, so I can know that, so you can know that I'm gonna destroy your ass, or just beat the brakes off you, and I mean that literally and metaphorically, right? Hello, Glendale PD. Lay your hands on me again, and what happened before is gonna be worse. So you got options. You can kill me, and then I'll be immortal, or you can release my children. You can stop trying to enforce fake law, or you can release my children. There's no more gray area. I'm done talking. You're going to end my life or release my children. That's where we are right now. Yeah, you understand me? I'm gonna read it to you. Higgins v. Levin. There is no discretion to ignore lack of jurisdiction. Joyce v. U.S. The law provides that once the state and federal jurisdiction have been challenged, it must be proven. Remember that? Maricopa boy ass county? When I challenged it on the record? We're not done. We're going back. You will be on the record for the record. Right? Let me finish. Let me just finish it here. Jurisdiction can be challenged at any time. That's not what I said. And jurisdiction once challenged cannot be assumed. It must be decided. I'm going to say that again. Jurisdiction once challenged cannot be assumed. It must be decided. That is Beso v. Utah Power and Light. My God. What does it say about your fake ass bonds that you be putting on me and more of us out here? Let's go over bonds. Public hazard bonding for corporate agents. All officials are required by federal, state, and municipal law to provide the name, address, telephone number of their public hazard and malpracticing bonding company, and policy number and the bond, if required, a copy of the policy describing the bond coverage and the specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud. 15 USC. The prima facie evidence and grounds to impose a lien upon the official personnel secured their public oath and service of office. 18 USC 912. That's just the law. That's not what I said. Okay? That's not how the Moors feel. It's not religion. It's the law. Let's keep going. Wherever having taken an oath before a competent tribunal, which is what you are. You're not even freaking court. You're just a tribunal. By definition of law, any court that's not the Supreme Court is considered inferior court. That's not my opinion. That's not crazy. That's not a Moore thing. It's the law. Let me keep going. United States authorities an oath to administer it. Willfully and contrary to such oath states or subscribes any material matter which he does not believe to be true, is guilty of perjury and shall be fined no more than 2,000 or imprisoned not more than 5 years or both. My God, you people think you can get off? Nah, I'm going to nail the coffin in. I'm going to make sure when your ass goes to jail that I'm going to bring you the snacks that my children are supposed to eat. You pieces of shit. Let's continue on here. A response is required within 10 days, which means by law, when I submit this, you will have 10 days. 10 days to get back. All right. What else are we going to go with? Oh, that's right, my man, Josh Barnes. Right? He just shared some crucial information, right? He said, go look at my timeline on Twitter. Commented directly, family. What did it say? It says ACES versus U.S. Because he commented on something specific. He said administrative law. What is he talking about? Got it right here. A judge ceases to sit as a judicial officer because the governing principle of administrative law that the courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentations, or rationale. My goodness. Is that something crazy or what? It's not what I said. That's just the silly ass Supreme Court. You know what I'm talking about? Got another one. We're going to do this as my family, KRS-One would say. I could do this all day. Cooper v. Aaron. No state legislator or executive judicial officer can war against the Constitution without violating his undertaking to support it. Man, let's keep this damn party going. Miller v. Kansas. The claim and exercise of a constitutional right cannot be converted into a crime. Man, let's keep this party going, gosh dog it. All of you that have problems with the fake ass DMV or anybody on the street, you see any Aboriginal person, and I'm going to speak for my people. Other people can go ahead and speak for their people. I'm going to speak for more of us. Any more out there having a problem, any NOI, any Hebrew Israelite, any so-called black or African American Negro Christian out there, listen and listen good. Chicago coach v. Chicago. Right? Ready? Let me break it down for you. Here we go. The use of highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right which the public and natural people cannot be deprived. Woo! That's not what I said. That's just the goddamn Supreme Court. Man, I got so much here. I don't even know. And for all you silly people running around, I don't care who you are, what group you're a part of. I do this from the heart. I do this for love. Because I want people to know, I want more of us to know why we're getting treated the way we are in a court of law. Not in the church, not in the masjid, in a court or inferior court of not law, because they don't even practice law. But, see that? Now I'm going to read it to you, family. What is Silverter Mortius? I probably didn't pronounce it perfect. I'm not great with Latin. I'm better with Arabia. Civilly dead. Dead in the view of law, the condition of one who has lost his civil rights and capacities and is accounted dead in law. That's just Black's Law Dictionary talking that silly law stuff, right? Not feelings. My grandmama didn't come from Crayola. I'm not black, Negro, or African American. We're going to cover all of those. And, you know, as time goes on, I'm going to cover these topics in greater detail, family. I know some of us are out there talking about this information, but not enough of us. Let's cover one more very important one, and then I got to get out of here. Right, I don't want this to be too long. Here we go. Probably couldn't read that real good. I really don't care. Here we go. This is a rough draft of this material. I'll be presenting it much better, but my man Eric Thomas said there's never a perfect time to do a great thing. So I'm going to do a great thing today. I had a great Zoom meeting last night. I linked up with the family, the real family. It was fantastic. We discussed the Million Man March, the MACD, and how we're not playing anymore, how the line is drawn in the sand. This is not a game. Okay? Statutes are not law. To be convicted under a statute, you must give your consent. I'm going to say that again in my best Dr. Umar, so you got two more coming at you. Ready? Statutes are not law. To be convicted under a statute, you must give your consent. You must give your consent. Let's keep going. A statute is not a law. Florida v. Natural Shevor. Florida v. First National Bank of Shreveport. A code is not a law. And Reself v. Ray. in a point of fact of law. Let's keep going. A concurrent or joint resolution of legislature is not a law. Coyne v. Flynn. Ward v. State. Todd v. Yale. What does that mean, family? That means basically all your garbage ass, no jurisdiction having ass mayors, governors, and even that punk ass president don't have the jurisdiction to tell a human what to do. Period. So I'm telling you to obey the law, family. Don't break the law, obey it. But first we have to know what the hell the law is. Mandates, statutes, codes, ordinances are not mother-freaking law. It's not what I said. The Supreme Court said it. Let's keep going. U.S. Supreme Court decision, family. The common law, the real law, 3 times. The real law, the supreme law of the land, the code, rules, regulations, policies, and statutes are not law. Same case law, Self v. Ray. Last part here. Ready? Here we go, and I got to get out of here. U.S. Supreme Court decision, all codes, rules, and regulations are for government authorities only, not inhuman creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez v. Ray Donovan, U.S. Department of Labor. I could tell you exactly where to find it, but I'm not going to do everything for you. Just going to throw it out there, okay? But when I enter it into record, Maricopa, garbage ass, no punk ass, jurisdiction having ass, Glendale, it's a wrap for you. You're going to pay a lot of money for what you did to me and my children. One more little one. Is it a little one? Marbury v. freaking Madison. One of my favorites. The Constitution of these, gosh darn it, United States is the supreme law of the land. And any law is repugnant to the Constitution is null and void of law. That's just Marbury v. Madison Supreme Court case law, backing up them crazy dudes, John Adams and them. You know, the ones that wrote the Constitution. I'm sorry. I'm going to read one more thing and then I got to get out of here. It's crazy. This comes from Curious Juris Secundum. I'm not good at Latin again, family. CJS. We're just going to use CJS. These are the basic 7 things that a person needs for that crazy thing we call due process. I know you see this shit on Law and Order, and I know you see it on Judge Judy. All them garbage ass, left ass, propaganda ass, fake ass news and television shows. All garbage. I love me some Ice-T. He's on a garbage ass show propagating garbage and lies. That's it. We'll get back to that on another day. I'll have a whole podcast on how garbage these shows are. From the top, 7 things, family. Several. Here we go. The accused person must be properly identified and identified in such a manner and fashion that there can be no possibility for mistaken identity. Keep going. Number 2. The statute of the offense, not statute as in law, because we know statutes are not law. Statute of offense, that means state what the offense is. Statute. Let's get our, what we call etymology on point, family. Brother Todd said this. We got to get out our feelings, overstand etymology. A lot of stuff is right in our face and we don't have time for these games. Here we go. The acts of the alleged offense must be described in a non-precedential language and detail so as to enable a person of average intelligence to understand the nature of the charge and to enable the accused preparation for defense. I didn't get that. Most people don't get that because they lied to you. I'm going to keep going. The accuser must be specifically specified and named. Named. One more time. The accuser must be specifically named. He or she may be an officer of the court or a third party, but some positively identifiable person, a human being, this is what law says, must accuse some certain natural person, must take responsibility for making or of the accusation and the agency or institution, corporation, artificial person, right? What did I tell you? Penhall v. Donaway, right? What did they do in Penhall v. Donaway? That's the case law that says the government is a corporation or artificial person. They can't even attain parity with the real. What did I say? So they turn your baby, your unborn child that's unprotected and innocent, into this artificial thing called a fetus. Then they can kill it. It's not a human. It's not protected by the Constitution anymore. And they turn your child, your human child, into this crazy thing called a foster child. Now, if a foster child is artificial, they can do what they want with it. They turn your simple ass into this thing called a minority, and you accept that title. Black, Negro, and African American. All the same as minor. Stripping this thing that President Trump spoke of called sovereignty. See, when he kept throwing that word around, sovereignty, that was pissing people off. I'm going to come back to, I got to have a whole special thing on the real president, right? We got to really clear the air. Let me do it. The accusation made against the accused, President Trump didn't get these either. The accusation made against the accused must be made in the manner penalty of perjury. If perjury cannot be reached the accuser, there is no accusation. Otherwise, anyone may accuse another falsely without risk of liability of punishment. This is where this is where the lie they tell you again that everybody's immune. No, they're not. They're not. Let's keep going. In order for the court or the accusers to comply with the 5 lawful elements as stated above, and as a condition for the accusation to be valid, the accused must be accorded due process according to the law, and the accuser must be complied with the law, proper procedure and form in bringing allegation or charge. Ain't that something? This is what the law says, family. The court must be a competent jurisdiction having actual judicial authorization. What is actual judicial authorization? Guess what, family? This come from this other crazy thing. Now, I covered this with my good friend Congressman Ruben Gallego, a Democrat, but he did the 50, what we call the old 52 fake on me. When I shared this information and I discussed it in an open forum, go watch the video. It's on YouTube. But anyway, what I was trying to get to, and he didn't allow me because, you know, he changed it. He dangled the carrot, and all of the people started talking about the carrot he was dangling, and they forgot that I asked a real question. So what is jurisdiction? Well, when you challenge it, the tribunal court must be a creature of its constitution and be in accord with the law of its creation, i.e. Article 3. Catch that. Article 3, judge. It's not what I said. This is the law, family. I'm not pulling this. I didn't write this myself. Right? I didn't. None of this is fake. Okay? Remember the importance of rule of identity, the sufficiency of your improper persona. This is what they don't teach you in school. This is what your lawyer damn sure is not going to tell you. Remember that if you hire a lawyer or an attorney to represent you, then you have given him or her your birthrights and have given jurisdiction to the court. Lawyers and officers of the court and their obligations are first to the court. And my best Dr. Umar are first to the court. 3 times, one more again. Are first to the court and not to you. The relationship constitutes what we call in law a conflict of freaking interest, family. See Corpus Juris Secundum, CJS, Volume 7, Section 4. Attorney and client's attorney first duty is not to the court and to the public. Let me continue this. Wherever the duties to the client conflict with those he owes as an officer of the court and administrative of justice for the Former must yield to the latter. Clients are also called wards. Go look up what a ward is, family. I can't do it all for you. In other words, it's a nice, pretty ass word for your ass's property of the court in regard to their relationship with their attorneys. Big ass secret they've been wanting to keep in the closet for a while now. Jurisdiction once challenged is to be proven not by the court but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the assessor. The court is one to rule of sufficiency of proof tendered. That is General Motors. McNutt v. General Motors. Maxwell v. Levy is the original case law. Look it up for yourself, family. Don't believe me. Look up everything for yourself. Territorial jurisdiction. Territorial jurisdiction involves the power, control, or authorize itself to render a judgment or decision. This involves matters of which is termed proof of jurisdiction. Of course, remember inherent right of nationals. Ask your attorney what is a national. Ask your local elected official what is a national. They don't speak about things if they don't have meaning. They don't make mistakes in law, family. They are extremely deliberate. An adverment of jurisdiction is a writ of argument that would be placed into evidence or firmly asserted in such an instant. The supreme standard for establishing jurisdiction powers and guidelines for their binding limitations would be and is Constitution for the United States Republic, North America. The lawful standard for all delegated judicial authority is specified and prescribed by constitutional law per the United States Republic Constitution, Article freaking 3. Caught that? Yeah, that's it for now, family. Peace, bless up. We do a little editing. I got a lot more to share. Okay, we're gonna keep rocking with this, no doubt. This felt good. I'm happy to be out the closet. Go ahead and do what my man Steve Harvey, brother Ben, all said. Your gift will make room for you. Let's see how much room. Bless up, family.